the literacy part, Sue, if you tap on Steve's name and you scroll down, I'm doing a little assumptions here. Do you see any replays that rooms that he's been in and appear on the replays?
Yeah, because it should show. Maybe. I don't know.
Yeah, I do, but only the rooms that I'm a member of.
Really? So it doesn't have a date of this happened?
No.
It doesn't have a June 27th?
No, it doesn't. No, my first one is June 10th when he was in another room that we were both in.
I just posted it in the...
Thank you.
Okay, and you're all talking about Steve's room. We're not talking about the Deep State Patriots, because I think I left it open. I hope I did. That's not the problem. Okay.
Will it let you click on the new Jumbotron link? Because that might be what you're after.
Oh, okay.
Does anybody have C-SPAN on by chance?
I think Elle did, but she just left. She was on the phone. Elle's back. Elle, go ahead, Elle.
If you just click on the link that I put in the chat, you can go right to it.
Yeah, I don't want to do it on my phone. I want to. Yeah, thanks.
I'm just letting Stu know that she can listen to it that way.
How? I'm sorry. I tried it one way. It didn't work. What did you say, Al?
Sue,
The
you're
same link as the
you're now
Jumbotron.
a member. Problem solved.
Thanks, Steve.
I found the wait list. It took me a while, but I found it.
I appreciate you. Thanks.
could do it.
All right, Steve, are you ready now?
Yeah, sure. So yeah, the case I focused most on was the case involving birthright citizenship. I guess I mean I feel silly saying in this room because I feel like there's a fairly high level of political literacy, but the court did not eliminate birthright citizenship, right? It technically didn't reach the merits of the underlying executive order which purports to eliminate birthright citizenship. It did not do that, notwithstanding about 4 clubhouse rooms talking about the end of birthright citizenship. And I don't mean to trivialize that what he's doing, but that's not what the case was about. 3 lower court judges in 3 different cases all found that the executive order was unconstitutional, and they issued orders to the government, not to apply the executive order. The plaintiffs were individuals in one case, and in the other 2 cases, they were largely actually state governments. And one of the things the state governments were saying is, look, we really do need a nationwide injunction because people come to our state from other states, people are moving all over the country, and there's all sorts of things we do in this state based on U.S. citizenships in terms of state benefits and all sorts of things. So we really do need to prevent the executive branch from purportedly taking away people's U.S. citizenship. So the issue in the case, the government appealed these nationwide injunctions. They did not appeal the underlying finding that the executive order was almost certainly unconstitutional, but just the scope of the relief that the judges gave in these 3 cases. And the Supreme Court said it is probably the case that these nationwide injunctions are not allowed under something called the Judiciary Act of 1789. But their logic, and this is the last thing I'll say, because again, we had a 2-hour room, I'm not going to be able to summarize everything here, but their logic really applies to the court, the Supreme Court itself. So this isn't the court saying, oh, we don't want lowly district courts issuing nationwide injunctions. Their logic applies to the Supreme Court as well. Essentially, what the majority opinion written by Justice Coney Barrett says is, we can tell the executive branch that they're acting unconstitutionally or contrary to some statute. We expect them to follow the law. but our ability to award relief may be limited to the people in front of us. So if 40 people sue and say they're trying to take away my birthright citizenship, we can say, no, government, you can't do that. That's unconstitutional. But now if they turn around the next day and go after a 41st person, the logic of the Supreme Court opinion is that 41st person would now need to go to court and say, oh, but what about the 42nd person, etc. It really is a strange and ridiculous ruling which essentially limits a court's ability to tell the executive branch what you're doing is unconstitutional. Just stop doing it. We don't need you to keep doing it and then just have lawsuit after lawsuit after lawsuit where people keep having to ask a court to stop you. We can just tell you to stop. It really is a ridiculous and stupid decision.
Steve?
Well, it takes away one more check against the power of the executive. It rebalances it. At this point, reinforces the fact that we have a judiciary that has less power.
Steve,
Anyway,
do you think that the Supreme Court is trying to thread a needle because it is so conservative, but it also knows what Trump wants, and it's trying to thread a needle between really not being activist or being originalist and I'm trying to make Trump happy at the same time?
I'm not sure I understand the question, but I'm still pretty sure the answer is no, because they're certainly not threading any needles. No, I think largely the Supreme Court is empowering him to do whatever he wants. So I certainly wouldn't describe anything they're doing as threading the needle. But the rest of your question about the tension between maybe originalism and giving him what he wants and all, I'm not really even sure I followed that, to be honest.
Steve,
I
have a question.
Well,
We have questions. I think Rick and I have questions. But Francis, what did you...
Well, the one question I have is you said that they said this is limited to giving release to the cases in front of us. Did they give relief to those cases or did they not?
They didn't, because, I mean, the posture of this case is so messy because it's like likely upon likely upon likely. So anytime there's preliminary relief, right? In other words, you're asking a court to freeze things in place to stop someone from doing something while the case continues. That's with the posture of this case, right? Lower court judges didn't say, we have made a final ruling, this is unconstitutional, the case is over, you can't do this anymore. They said, it is likely unconstitutional. By the way, that doesn't mean that they're not confident that it's unconstitutional. It simply means that the standard is only that it's likely that the plaintiffs would prevail. So the lower court said, it is likely that these people complaining about your executive order will win.
everybody knows that.
And it will cause irreparable harm if we allow you to go ahead and enforce your executive order. So we are ordering you not to withdraw the case. At the Supreme Court, same thing. The Supreme Court isn't making a final ruling about whether it's constitutional. Right. It isn't even making a final ruling about whether the court does or doesn't have the power to issue a nationwide injunction.
That's why I thought they were threading the needle.
It is saying you likely don't have the power, district court. So therefore, the government is likely to win on the issue of whether you have the power. So we're going to lift the injunction and we're going to let you go ahead and, we're going to tell the court a nationwide injunction, probably not within your power. reconsider your injunction. So it is possible that the district courts will say, okay, we're refining it, now it's not, we're limiting it somewhat. The court didn't literally order the Supreme Court didn't literally order the lower court to issue an injunction that only applies to the plaintiffs before them. So there is some unpredictability, at least a little bit, in what the district courts will do. But the Supreme Court has previewed its thinking on this issue. And if a case came before them where it really was in front of them, whether or not courts could issue these kinds of injunctions, they've already said what they would do. So I think most people are covering this as if they've said that nationwide injunctions are essentially not legal. And that's fair, the rest is technicality. But it's unclear what the lower courts will do. The states it's unclear what they'll do. But the idea that it is going to be one important tool that judges have to stop or slow down the Trump regime has been taken away or at least blunted. And I think one of the things that's most remarkable about the opinion is that they don't talk about birthright citizenship at all. And by that I don't mean that they should have addressed the issues, the merits of that. The merits of the executive order in terms of its constitutionality were not before them. That is true. But to issue a ruling like this without even saying one word about what it means practically, right? One word about the fact that we're saying you can't issue this kind of relief does mean that as an effective matter, people's birthright citizenship can now be challenged by the Trump regime, and they can be put in a position where they're treated as if they are not citizens. It's like, oh, well, I guess that's just the way the cookie crumbles because of the Judiciary Act of 1789.
And the timing, and then swept up in the 3,000 person a day $1 billion enterprise.
Yeah, and so as a practical matter, I think this is a thing that it's hard to talk about because it's kind of abstract, but one of the main features of the Roberts Court is this way in which they are often divorced from the practical realities of their decisions, the ways in which there's no pragmatism to this court at all, right? Everything is discussed as if there's some, sacred text. We're oracles who define what the sacred text means, and it just means what it means. And if